Hi, I'm Lou Dubuque, Executive Vice President of the New York State Builders Association. Today, we're doing a webinar on the Construction Industry Wage Theft Act. This is the second such webinar we've done this fall, the first one on the HERO Act. You can find that on NYSBA's YouTube page. And both of these webinars are being brought to you by the NYSBA Research and Education Foundation. And with that, I will give this over to Tom Tripodianis from Welby, Brady, and Greenblatt, and also NYSBA's Legal Defense Fund Chair. Tom, the floor is yours.
Thank you very much, Lou, and thank you to the New York State Builders Association for the opportunity to make this presentation. And thank you to everyone who is listening and watching at home. My name is Thomas Tripodianis. I'm from the law firm of Welby, Brady, and Greenblatt. I'm currently the managing partner of the firm. And we specialize in the construction industry litigation, labor, and employment for the contractors as well. We have offices in Albany, Manhattan, White Plains, New Jersey, and Connecticut. So with that, we'll begin. Today we'll be covering the Construction Industry Wage Theft Act. It is not a new statute, but there are new amendments to it. So over the Labor Day weekend this past September, Governor Hochul enacted Bill A3350. This new legislation will hold contractors, and that definition includes general contractors, prime contractors, construction managers, joint ventures, or any combination thereof, jointly and severally liable for wage theft claims by subcontractors' employees on construction projects. So jointly and severally means the employee can sue either the sub, the GC, as that definition we just went through, either one or both at the same time for any underpayments. Unlike the counterpart in the public realm, there is no criminal liability contemplated by this particular statute. The new legislation does apply, and it's effective. Well, it's immediately effective, but it applies to any contracts entered into, renewed, modified, or amended on or after January 4th of the coming year, 2022. That is significant because there may be an award of a contract in 2021, but the contract is not actually entered into until the following year, which would bring it within the purview of the statute. One thing that question that comes to my mind, for which I unfortunately don't have an answer, obviously there's no case law on this yet, is the question of modified or amended. So if there is a contract that was signed, entered into in 2021, and in fact, maybe even work had begun on that contract in 2021, if there is a change order to that contract in 2022, would that qualify as the contract being modified or amended? I think a strong argument could be made on both sides of that coin. So we'll wait and see if and when a case comes up and how that turns out. There are exceptions to the law for certain residential projects. They include home improvement contracts for owner-occupied dwellings and home construction contracts for 1 to 2 family dwellings, except where that contract results in construction of more than 10 such dwellings on one project site on an annual basis. So things like subdivisions are intended to be falling into the purview of the statute. You cannot contractually waive any of these provisions. So if you try to put a provision in your subcontracts that says, or have the employees sign a waiver saying that, I waive the benefits and the rights provided me by the Wage Theft Act, they would not be upheld in court. They would be void as a matter of law. The only exception to that is if there's a collective bargaining agreement with a bona fide building and construction trade organization, and the waiver has to explicitly reference the waiver of this particular statute. And the reason for that is most collective bargaining agreements will have such enforcement provisions in them already. So therefore, they're trying to avoid any conflict or any duplicative coverage between a collective bargaining agreement and the statute. So what's covered? So a contractor's liability covers claims by subcontractors and or workers for unpaid wages. It also would include any wage supplements. So for example, health coverage, welfare benefits, retirement benefits, vacation pay, paid time off, that type of stuff. All that is included under the statute. The time frame for bringing a claim is 3 years. So that is contrasted again with normal breach of contract causes of action, which would be 6 years, or even wage claims in the public realm, which would also be 6 years. So there is a shortened statute of limitations for these claims, 3 years, although 3 years is certainly not a short statute of limitations by any stretch. So what are the remedies available for violations? Well, first of all, if an action is brought, there would be costs and attorney's fees. So that would include not only you paying your lawyer to defend the claim, but also you paying for the lawyer that brought the claim on behalf of the claimant. Expenses not to exceed $50. Liquidated damages, which basically doubles the amount of the unpaid wages. And then if there were willful violations, so for example, if the GC and the subcontractor colluded in these underpayments for whatever reason, then the damages would be triple, what's called treble damages under the statute. There's also, of course, pre-judgment interest, and that would be running at 9%, as well as post-judgment interest, which would also be running at 9%. Two things that probably everyone should be familiar with, I hope, are the notices that are required under the labor law. So they are brought into this statute as well. So they're in section 195 of the labor law, and they are the wage theft notices that are required. So when you have a new hire or there's a change in pay, there's supposed to be a notice that is issued. LS 54 is the form number given to it by the Department of Labor. You can download it off the website. You don't have to use their form, but you have to include the information that's required under that section of the statute. So the second one is your what's commonly referred to as a pay stub, which basically tells the employee what they're being paid and how they're being paid and the deductions that are coming out of it. So failure to provide either one of these would result in a maximum $5,000 penalty each. And if you look at the statutes, there's for each violation of the statute, there's an amount that is charged. So the cumulative amount is the $5,000 cap that we're talking about here for each violation. A new statute was also added to the general business law under on section 756, and it's called -F in this provision. And it allows contractors, so it gives contractors some ability to protect themselves from liability under the statute, to audit a subcontractor's payroll records and practices to safeguard against such claims. A very powerful tool. Encourage everyone to take advantage of it. And we'll talk a little bit more about that, how they would do that down the line. So what does the statute give you? Under 756, you can request that the subcontractor provide copies of certified payrolls, a list of the workers, including any alleged or true independent contractors, their anticipated contract start date, the scheduled duration of the work, and the sub's local union contact information if they happen to be a union contractor. A subcontractor's refusal or failure to provide this information upon request will constitute a basis for the contractor to withhold further payments to that sub. Statute is unclear as to the amount of the withholdings. Certainly, obviously, if the contractor has knowledge of the number of hours that a particular workforce has put in, whatever the equivalent wage would have been to that would be a justified withholding. But again, because sometimes this is hard to know, the information is not readily available, an argument supposedly, I guess, could be made that any further payments would also have to be withheld, although be prepared in that situation for a counter argument by the subcontractor that the withholding in such a situation was excessive. So what can a GC do to protect themselves? So obviously the use of the requests for the information that we just talked about is crucial. You should be requesting at a minimum certified payrolls. You should be comparing them against your daily reports to make sure that a particular sub, if they had 3 workers on site and they were doing, I don't know, carpentry, roofing, and plumbing, that you have that corresponding information on the certified payrolls that are being submitted. A close look, again, at independent contractors on behalf of the GC. For example, you may get a claim that this is a single person entity that I've subcontracted with. They're an independent contractor. And therefore they are not subject to either minimum wage or prevailing wage, possibly, depending on the project. These types of claims are suspect, and further investigation would be required. At a minimum, I would want to see proof that there's actually a subcontract in place between this individual and your subcontractor, that the subcontractor has requested insurance from this individual, and if it's an entity in the entity's name, and that there are additional insured requirements contained in those contracts. I'd want to see a copy of at least the certificate of insurance from that alleged independent contractor. You might want to vet, see if they have a website, see if they have a business card, see if they do business with anybody else. These are the common types of hallmarks of a true independent contractor. And if they don't exist, then I would seriously question the practice and the allegation that this is truly an independent contractor who is otherwise not entitled to either a minimum wage or a prevailing wage. And certainly I would think until your questions are satisfied, withholding would be proper in that situation. So you would also want, obviously, to include indemnification provisions in your contracts with the subcontractors. So if there is a claim that that particular sub has not made proper payments to their employees, that the subcontractor agrees to defend and indemnify you against such claims. You may want to also hire a payroll administrator that will do periodic investigations at the site, including questioning particular employees if they are being paid a proper wage, what their hours are, et cetera, and then double checking those against the certified payrolls that are being submitted. Your indemnification provisions should also include the provisions for attorney's fees and include any penalties that are imposed, not just the amount of the wage, but also, like we said, the liquidated damages, the treble damages, and those $5,000 penalties for failure to provide the notices. So any violation by the sub of the labor law that is visited upon the contractor, there should be defense and indemnity provided for that, along with the cost of defense if the contractor chooses to hire their own attorney to defend that claim. If you want to have that provision, that is something that you would need to add to your contract in order to do that. Another thing to consider is increasing retainage or delaying the release of retainage. Ideally, I'd like to see retainage held for the period of 3 years, which is the equivalent of the statute of limitations. But I realize that as a business practice, that may not be viable. So perhaps you can do a sliding scale where retainage is released periodically over those 3 years. Maybe even considering an increased retainage. So if you're holding 5% now, you might want to hold 10% at this time. Another risk allocation is payment bonds. So a payment bond is issued by a surety licensed to do business in New York. And payment bonds typically cover claims of unpaid wages. But along with payment bonds come obviously the premiums that are involved. So there's increased cost. And number two is not all subcontractors are going to have a bonding line or are going to be able to get a bonding line, there is a vetting process that they have to go through by the surety. They have to show sufficient financial assets in order to for the surety to issue a bond, because the sureties, unlike insurance, don't expect claims. They expect to collect premiums and never hear from their principals again. Obviously, this is not the case, but they are, when you apply for a surety line, you're going to sign something called a general agreement of indemnity. So that is not holding only the subcontractor entity liable if the surety is obligated to pay out on any claims, but the surety is also going to seek other indemnitors, typically the individuals behind the subcontractors, so the owners, potentially their wives, and anybody else holding significant assets that are pledged to the bond at the time of application. You will have to be, contractors are going to have to be vigilant and really take a close look at your sub's payroll practices to make sure they are consistent with legal requirements. You may want to actually ask to see the copies of pay stubs, copies of the wage theft notices, copies of canceled checks as well. You may want to interview employees to make sure that the information that the subcontractor is giving you is consistent with what the employee is telling you the business practice is. You may, of course, go down the path of issuing joint checks or direct checks for payroll if you have such a provision in your contract. However, that is a double-edged sword. Potentially a claim that can be made that now that there is a direct relationship between that employee and the GC who is issuing the check. So you're going to need to speak to an attorney before you decide to take that step. And there are going to be certain documents that your attorney will provide you that you're going to want the employee to sign, basically acknowledging that this is being done more as an accommodation and not as intended to create a direct relationship between the parties. You would also need, if the contract provision doesn't exist, you would want something signed by that particular sub acknowledging that they're aware of the direct payment, they're aware of the amount, they don't dispute it, and that it will operate as if the payment was made to that particular subcontractor, thereby reducing the balance owed to them. What can subcontractors do? So number one, take a look at your payroll practices, consult with an attorney, maybe even your payroll company, make sure you're in full compliance with the New York labor law. I've seen a lot of cases, especially where the pay stubs and the wage theft notices are not being provided. Make sure you're properly classifying your employees and giving them the proper wage as well. The penalties are now being amplified, of course. So you not only will you face obviously the direct claims by your employees, but also now claims from the general contractor should there be a violation as a result of this new legislation. There were potential amendments to the act that were proposed. Only one of them has made it in, which is a written notice requirement that should be sent to the GC within 90 days of a missed payment. Unfortunately, this does not necessarily provide an opportunity to cure, and it's unclear at this time whether if that is corrected, in other words, the employee is made whole and paid within that notice, if the other penalties still won't apply anyway. Other suggestions included a whistleblower protection. So none of the ones I'm talking about now actually made it in. Limitation on liability if there was an immediate withholding by the general contractor upon receiving a notice, or removing or limiting the general contractor's liability for liquidated damages. So taking out that punitive side of it. So unfortunately, none of those have made it in. It's not to say that statute can't be amended in the future to add things like this, but at this time they're not. So that remains to be seen what happens. So this is what I like to call the speed round. So 5 things to know. So number 1, law was passed and signed into law by the governor on September 6th. provides for joint and several liability of the contractors for unpaid wages, which includes wage supplements as defined by the labor law. So vacation pay, health and welfare, reimbursement for expenses like uniforms, tools, think about that. Number two, all other remedies that are available under Section 198 of the law are included under this. So again, liquidated damages, the max $5,000 penalties for failure to provide the proper notices, attorney's fees, treble damages as well. Three, legislation amends Section 198E of the labor law and adds a new Section 756-F to the general business law. It takes effect January 4th, 2022, but may apply to contracts that were entered before that date, depending if they're renewed, modified, or otherwise amended after January 4th. The statute of limitations is 3 years, as opposed to the 6-year statute of limitations for breach of contract actions, or direct actions by the employee against the subcontractor. Those would be 6 years. 4, liability cannot be waived unless there is a collective bargaining agreement, which specifically references this section of the labor law. So this legislation will apply to all non-union contracts without exception. Again, there are exemptions for certain types of projects in the residential industry, which we already went through. 5, you may contract as a GC for defense and indemnity from the subcontractor should there be a underpayment, but be careful that indemnification provision cannot in any way affect the actual unpaid laborer's right to bring an action. The law does provide you with specific auditing practices and provide you for mechanisms to request specific information and documentation from the subcontractors, and a failure to do so would result in a basis for the contractor to withhold further payment from the subcontractor. This is designed to encourage the GC's active participation and auditing of the subcontractors' payroll practices. So in essence, I guess in a sort, you've been deputized by the DOL to enforce labor and wage laws. Unfortunately, this is going to be a difficult liability to mitigate. We did go through some steps that would be helpful, but there is no silver bullet or 100% shield against these claims, especially, for example, the failure to provide notices, which are not always immediately evident. Another type of claim is when a laborer is working off the clock, so there may be an overtime violation there. So if your daily reports are just showing, for example, that these people were here on this day and did this, and you're not, and I don't expect you to, recording the number of hours that those people put in. If they happen to put in 10 hours a day, but they were only paid for 8, that necessarily wouldn't be immediately evident on your certified payrolls. So that creates a difficulty and an exposure there. There are also requirements in terms of frequency of pay, how often an employee has to get paid. So if they are submitting certified payrolls, but that frequency of pay violation exists, that could be potentially visited upon the GC. So again, that's where the active interview process or the hiring of a outside entity who audits these labor practices, that's where these types of things hopefully would be picked up. Again, an administrative burden, and with administrative burdens is a financial burden, which of course is going to raise the cost of all projects. So with that, I thank you. If you have any questions, please feel free to give me a call. My information is on all these slides. I believe the slide deck will be made available by Lou at the State Builders Association. But again, if you have any questions, please feel free to contact me either by phone or email. Again, thank you for the opportunity and good luck to you all.